The next case to come before the court today is State of Ohio v. Shawn Dobson. We have only the appellant here with us today, so you will have 15 minutes to present your argument. Please come before the podium, introduce yourself, and remember that the arguments are being recorded, so please keep your voice up. You should not use the names of children or minors or victims. Should that be relevant to your argument, you can refer to those folks by their initials or generic terms like the child. We have read your brief and we're ready to proceed when you are.
May it please the court, my name is Stephanie Zernick, and I am from the Medina County Prosecutor's Office representing the appellant, in this case, the State of Ohio. The State of Ohio has a substantial right to have its statutes enforced under Revised Code Section 2505.02. In the case at hand, the relevant statute is Section 2919.21b1, which provides as follows. No person shall abandon or fail to provide support as established by a court order to another person whom, by court order or decree, the person A is legally obligated to support, or B was legally obligated to support, and an amount for support, 1, was due and owing prior to the date the person's duty to pay current support terminated, and 2, remains unpaid. Now, the statute was amended February 11, 2019 in order to add the provisions regarding a person who was legally obligated to provide support. This affects most likely thousands of child support obligees across the state of Ohio. However, if the statute is read prospectively instead of retroactively, many of those obligees would be left without a remedy to collect child support that is owed to them. And of course, public policy is in favor of making sure that child support obligees receive their child support. In this case, Shawn Dobson was indicted on 3 felony counts of non-supportive dependence spanning the time period from April 2013 to March 2019. The trial court amended the first count of the indictment to only reflect the time that Dobson had a current support order from April 1st, 2013 to July 2nd, 2014. It then dismissed the second count of the indictment as that count occurred after the current support order terminated and before the amendment to the statute. It then amended the third count of the indictment to only reflect the time from February 11, 2019, the date the statute was amended, through March 2019, then dismissed that third count as the remaining period only qualified for a misdemeanor and the statute of limitations had already run. In a similar case, in Ray S.J., 2005 Ohio 3215, the Supreme Court of Ohio held that a juvenile court order which dismissed one charge and amended another charge, was a final order that affected a substantial right of the state and prevented a judgment on the original charges. Here, the only count remaining in the indictment is count 1, which no longer contains the 104-week consecutive week period needed to raise non-supportive dependence to a felony. The remaining period is a year and 13 weeks. However, Dobson was incarcerated from July 2012 to May 2014, which leaves only the time from May 21st to July 2nd remaining in count 1, about 43 days, and I believe the math in my brief is wrong, Your Honors, I apologize. The state has been prevented from prosecuting the indictment as it was originally charged and will be unable to obtain a judgment against Dobson on felony charges of non-supportive dependence. It's the state's position that Section 2919.21b1 is meant to be read retroactively. The amendment was a response to the Supreme Court of Ohio's decision in State v. Pittman that arrearages-only non-support cases could not be prosecuted. And the Supreme Court in that case reasoned that since the language of the statute was in present tense only, there had to be a current child support obligation in order to prosecute an upward order. The General Assembly, in response to that decision, then amended the statute to include situations where a person was legally obligated to support a dependent so that the Pittman loophole would be closed. Since the statute includes language both in the present tense and in the past tense, this shows the General Assembly's intent to have the statute apply retroactively.
Well, counsel, with respect to the past tense, isn't the language in the past tense only there because child support has to be owing, as in it came to be as being owing in the past tense? You can't prospectively say you're guilty of something because you haven't paid child support moving forward.
Correct, Your Honor. That is part of the past tense language, that there is child support that was previously due and is still owing. However, it also says that the person was legally obligated to support someone, which makes that difference, we believe, in thinking about whether the statute applies prospectively or retrospectively.
So absent any, and I understand the argument, but absent any specific language about retroactivity, we have to do the substantive versus remedial analysis, don't we?
Yes, Your Honor, and that's exactly my next point, that the statute is not an unconstitutional ex post facto law. Statutes are presumed to be constitutional, and statutes that are remedial and not substantive do not violate the Ohio Constitution, even when they are applied retroactively. The statute is substantive if it impairs or takes away vested rights, affects an accrued substantive right, imposes new or additional burdens, duties, obligations, or liabilities as to a past transaction, or creates a new right. The statute is remedial, on the other hand, if it substitutes a new or more appropriate remedy for the enforcement of an existing right. And child support obligees have always had the right to be paid arrearages. The Supreme Court of Ohio has held that a later enactment will not burden or attach a new disability to a past transaction or consideration in the constitutional sense, unless the past transaction or consideration, if it did not create a vested right, created at least a reasonable expectation of finality. There is no vested right not to pay child support, and especially no vested right to get out of paying child support by refusing to pay child support until the child is emancipated. There is no new burden created by requiring Dobson to pay his child support. The commission of a felony, such as not paying child support for the required number of weeks, is not a past transaction with a reasonable expectation of finality from the Supreme Court. Therefore, the statute's amendment was remedial and not substantive. If there are no further questions, the state of Ohio would respectfully ask this court to reverse the amendment of count 1 and dismissal of counts 2 and 3 of the indictment. Thank you.
Very well, thank you. Counsel, the court will take the matter under advisement, issue a decision in due course. The court, of course, will mail a copy of the decision to you on the day it's released, and the opinions will also be posted on the Ohio Supreme Court website.
Thank you, Your Honor.